LaShawn, how was your weekend? Yeah. I really enjoyed the birthday. 90. Oh, yes. That is so awesome. Oh, that is so awesome. Oh. And then, you know, on every corner, they're selling Girl Scout cookies, and I tell them I'm dining. So I did buy some, but I've been buying them and giving them away. So tomorrow you guys will have Girl Scout cookies. Yeah. So I'm doing the Samoas in the do-si-dos. So I figure we throw in some peanut butter, we'll be okay. And they got a recall on some items, chocolate covered items. So we'll see what's up with that. All right, Victoria, thank you for letting me know that the line is long outside. Yes. And then over the weekend, I don't know what was happening. They shut down downtown.
That was a Calvin still down.
Oh. Yes, they shut it down. And, you know, I was trying to get to the Witty for an event for judges. And it took me 30 minutes to leave from De La Rosa to get to the Witty.
Taking one of the horses.
All right, everyone, I'm going to call the docket. When I call the docket, stand and let me know you are here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. And Deputy Laura, if you can have them bring up McIntyre, see the council is in the Zoom. Jerry McGee, Nicholas Henderson, Johnny De La Rosa, Cody, thank you, Cody Salazar, Millard Cummings, Millard Darrell Cummings.
I think that's in custody.
Oh, it's custody?
Oh, no, I'm sorry.
That's okay. Nicholas Cameron, custody.
He's custody.
Christy Brown. Gabriel Diaz. Dylan Skinner, custody. Tommy Lopez, custody. Luis Fernando Acura. Simeon Novell.
That's a motion to suppress.
All right, is that Simeon
Novellis?
I guess he's in line. Juan Perez, custody. Charles Wanless, custody. Okay, Charles Wanless. That would be a great name if you were in Harry Potter world, because you don't have your wand. All right. Angel Placencia. Angel Placencia. I called his name correctly and he's not here to hear it. Michael Anthony Medellin. Ruben Rendon, Jose Ovidio. Custody, Alexander Aguilar, Michael Gonzalez, custody, Jessica Marie Garcia. Ezekiel Martinez, Arturo Camacho, Christina Martinez, Cody Cross, custody, Adam Adrian Herrera, Andrew Garza, Jordan Davis, Arturo Martinez, Tamar McIntyre, Kendall Smith, custody. Clinton Camacho, is he in custody or not?
Not in custody. I do have an update from Veteran Court on that.
All right, thank you. Christopher Salinas, custody. Nicholas Henderson, custody. Elliot Vela, custody. Is there anyone who came in late or your name was not called? All right, who are the three ladies on this row? All right, so let me explain something to people in the audience. And Deputy Laura, please follow these instructions. You are not allowed to talk to inmates in the box. If you talk to any inmate in the box, if you wave to them, the deputy is going to tap you on the shoulder. There's no due process. You just are going to be excused from the courtroom, and you will not be allowed back in this courtroom unless there is some hearing where you're needed as a witness. Does everybody understand? Visitation is not going to be in this courtroom. And I know people may think that's mean of me, but here's the thing. The deputies are in charge of security. And when people start talking to inmates, that raises concerns for them. So do not talk to the inmate. Attorneys, you are not ready to approach the court unless you've talked to the prosecutor and unless you've talked to your client. Once you ask for your client to be brought out by the deputies, do not leave the courtroom because there's a limited number of inmates who are allowed in the courtroom at any one time. And if you leave the courtroom after your request, you're being selfish to everyone else. If you have a client who wishes to speak to the court in a language other than English, you will need the interpreter here, whether you speak the language or not. So when you're ready to approach, be sure to let them know that you need an interpreter. To the staff, when we're on the record, attorneys, when we're on the record, you will know, because I've called the style of the case. Do not approach when we're on the record. Don't do it, because I would like for 100% of my focus to be on the persons in front of me. And Mr. Maurer tells me he has a motion to suppress. So I'm going to need to be 100% focused so that I can hear whatever case law anyone is presenting. When we are on the record, do not talk behind the court reporter. I know sometimes people get in their own world. Don't talk behind the court reporter. Just ask the deputy to move your client over to the other end. They will be happy to do so. Today is Monday. We're not retired. We thought we would be retired. We're going to have to live with the fact that we're not retired, and we're probably not going to be retired for a while. So let's have a great day. It's Girl Scout Cookie Week. It's Black History Month, or as I tell people, it's Black History every month. Black history is everybody's history. So everyone, please confer.
My client is in line downstairs, so I'll come back to you. We can make that.
All right, thank you.
Okay.
A quick joke for you, Jeff.
Yes, sure.
So just the other day, my wife asked me when I was going to retire, and I said, "When you bury me." That's when.
So that doesn't happen.
No, what I meant was I'm going to be one of those old guys that are walking around the courthouse.
Oh, yeah. Oh, but Sean, I also saw a movie this weekend. Just one of them days, or one of them days. Yesterday. Okay, it was so hilarious. And it, you know, I was telling everybody, it was sort of nostalgic because you remember back in the day when they would have those type of movies, and then when it ends, they do the writing to tell you what everybody is up to. Yeah. Oh, yes. I need the file on McIntyre, please. Thank you. And are the motions in here? All right, thank you.
We won't have a spreadsheet.
PowerPoint and everything already loaded up.
I have a spreadsheet. PowerPoint.
Oh, but Sean, when you went, I always go early so I can see the trailers for movies that are coming up. Did you see the trailers?
I mean, all of the trailers that was for the movies were scary movies.
Yes.
Every single one. And I was like, my goodness, I don't watch this.
Okay.
I
The
couldn't
one-
escape it.
The one that's called The Lady in the Yard. Oh, I would tell that lady, get out of my yard. But
I mean, every.
Every last one.
Scary there.
but am I going to go see it? Yes, I am. But well, I think I'm going to go see The Woman in the Yard because I need to know why these people didn't tell her to leave their front yard. And then
I have a
They're
feeling
not allowed
that
to put it in.
I don't think she's real.
I don't know.
I think so.
And then the heart guy. The guy with the hearts in his eyes. Okay, if you know this is happening on Valentine's Day, you know what I would tell my significant other? We're going to celebrate Valentine's the next day and just stay in. We're going to sit this one out.
Like,
Yes.
yeah. My 12-year-old saw that trailer
Mhm.
at the beginning of the YouTube video and he was like, Daddy, that looks hilarious.
Yeah.
Like, it didn't look scary. He goes, no, it looks like the stupidest thing I've ever seen. I'm
Well,
like,
you know,
whoa. He
do you-
came out like guns a-blazing, said
Yeah.
really dumb.
do you remember when they would have those movies? Jamie Lee Curtis was in a movie where they were all on a train. And I was thinking, what high school do they attend where their prom is on a moving train? But
That's funny.
I think it was called Prom Night.
I would
She was in
imagine
prom night.
it wasn't too.
Yes.
He was a slasher queen.
Yeah.
He was.
Where's that? Where's that? Piano music for Halloween?
Oh, yes.
That's
That was
good.
creepy.
The other one my son said was, do they have a horror movie for every holiday of the year? Like, are they missing any? I
Yes.
said, there is not a July 4th horror movie that I'm aware of. So, I mean, maybe.
Isn't
well,
Independence Day
It's
sort of
not-
like a horror movie?
That's not a horror movie. That's an alien movie with Will Smith. That's different. I specifically.
I mean, there's some jump scares in there.
Oh, yeah, when the alien pops out. Yeah, that's good.
No, I don't care. I start.
No, I'll take that.
Take a row, sir. Take a row. What's your name?
You available?
No.
The motion I need is their motion for continuance.
$199.
No,
Dr. Lynch,
yes, I have.
Andrew Garza, I walked in with him. I'm not sure if he checked in.
All right, we'll find out.
I was gonna walk into the hallway. That's the reason.
Okay, sure. Who's here on McIntyre? You all ready?
Your Honor, we're ready to proceed.
Court is calling. Everyone needs to be quiet. Court is calling 2019 CR 12495, State versus Tamar McIntyre. Can I have parties announced for the record for the state,
Jason Garrett, Your Honor.
for the defense?
John Hunter for Mr. McIntyre, Your Honor. I believe that
Where is he?
Mr. Goldstein is.
Yes, he
appearing
is.
by
He's here.
Zoom.
Good morning, Your Honor.
Good morning. All right, this is scheduled for jury selection on Friday. Why are you all here? What motions do you have?
The state filed just a motion on limine, Your Honor, just for a few things. I don't know. It was filed this morning, so I don't know if defense has had an opportunity to view it.
I've not received service of it, Your
All
Honor.
right.
Mr. Goldstein advised me just by telephone about 2 minutes ago that he saw that it had been filed, but I don't believe he's read it either.
All right, so
I
with
was
regards to-
unable to open it, Your Honor, and my apologies.
No problem. With regards to motions and limines, I do not know anything about this case. So as far as me ruling on any motion and limines, unless it's something that's specifically in case law where it's not allowed, then of course the court will make its ruling. But if it has to do with whether or not certain questions should be asked or whether or not certain evidence should be presented, y'all will need to approach prior to going into whatever subject matter you have with regards to motion and limines from the defense or from the state.
And Judge, it's not something associated with voir dire, it'd be associated with the actual case in chief and punishment. So it's not a question of hearing it before we pick a jury.
All right. Any other-
Your Honor, if I may, I'm particularly concerned about a recent disclosure that the state's key witness has given prior sworn testimony before a previous judge in this court regarding our client's participation in this case. And I believe I would like to make sure that we're able to supplement our motion for continuance with state versus.
Just 1 second. Let me finish addressing the state. Are there any other motions?
Not at this moment, no, Your Honor.
All right, defense, any motions?
Your Honor, we filed a motion for continuance back on January 24th, and I informally had advised the court of the fact that that was a concern. Let me update the court since then, because there will be need for us to supplement.
All right, and
because of its
before
verification.
everybody updates me on the supplemental as it relates to the motion for continuance, let me ask everybody a question. Did I not ask you all what date you all wanted for jury trial? I had given everybody continuances before. People wanted to go on vacation or trips with their family members. I let them go. I said, talk to the coordinator and choose a jury trial date. Is my memory faulty, or is that what I did?
Your Honor, let me, if I could give.
Well, no, we're gonna get to that. But did I do that?
Yes, Your Honor.
Yes, Your Honor.
Did you all choose this date as your jury trial date?
Yes, sir.
Did
Yes.
you all choose Friday as the date for jury selection?
Yes, sir.
All right, and then today was supposed to be for motions. And this was done, I think, back in November. So before I get into your motion for continuance, because I want the record to be clear, this case has been on the court's docket since 2023. We are now in 2025. So May 8th, 2023, this case was set for discovery. It was called back on June 5th, 2023 for discovery. Then it was called back on August 3rd, 2023 for discovery. Then it was called back on October 5th, 2023 for discovery. Then it was recalled on December 7th, 2023 for discovery. Then it was called on January 30th, 2024 for discovery. Then it was set for jury trial. And it did not go to jury trial because there was more discovery. So then we came back on April 2nd, 2024, and it was set for jury trial for October 14th, 2024. Then everybody said, we can't do that. We have vacation, we have this. Then we came back on September 19th. I'm sorry, we were here on April 2nd, 2024. Then we came back on August 27th, 2024. Then it was recalled for September 19th, 2024. Then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then we had the jury trial scheduled for October 14th, 2024. Then we came back on November 21st, 2024, discovery acknowledgement signed. And then we came back on December 2nd, 2024. I told both parties I wouldn't charge a continuance to either side. Then we came back and here we are. So I'd like the record to be clear on what is happening in the case. So now I'll hear your motion for continuance.
Yes, Your Honor. With respect to the court's recitation of the history, I think it's important that we make clear the settings that were held in September of 2024. We had every reason to believe when they were being discussed in the spring of 2024 would hold based upon the production that the defense had already received and based upon the state's representation that apart from jail correspondence, which was of little evidentiary value in the case, no additional discovery would be forthcoming. In July of 2024, the defense, in getting ready for that trial setting and making preparations, found a one-line entry on one page of what is otherwise a very extensive and copious amount of paper discovery, referencing a remark by a detective that he wished that he could also have in his possession ballistics reports done on a firearm that was recovered from Jalen Bell, who is an indicted co-defendant in the case, who has already pleaded guilty and been sentenced to prison. We, based on the discovery, came to the conclusion that no such firearm had ever been tested and that its origin, or its location at that given moment was unknown. We began conferring with Jason Garahan for the state about this matter, and we tried to bring this matter to the court's attention. Mr. Garahan engaged.
Wait a minute. Let me stop you right there. What do you mean you tried to bring it to the court's attention?
We informally approached the court, I believe, on a couple of different occasions to advise that this was a matter of concern, and then eventually we filed
Are you talking about
motions.
when you file the motion for continuance?
The original motion for continuance was not the first time that we had made the court aware of the issue, is what I'm trying to avert to. We were concerned almost immediately in late July, early August of 2024, that this was going to be a matter of concern. And we were trying to get to the bottom of what was going on.
But you all picked the court date
Well, Your
for
Honor,
the jury trial.
yes, and as I'm explaining, that court date was selected sometime long ago. In the course of preparation for that, we found a very, very, very small reference to this firearm and what is otherwise a very, very large amount of evidence. We advised the prosecution of that fact and sent over a draft motion to compel about anything that was related to it. But of course, we didn't need to file or urge the motion to compel because Mr. Garahan, who has been doing an excellent job keeping up with this, was similarly, I believe, and correct me if I'm wrong, not really aware of the firearm recovered from Jalen Bell because previously it had had such little significance.
So you didn't file a motion with the court urging the court to compel any evidence, correct?
We approached the court and advised the court of the fact that we were trying to sort out this discovery matter between the parties, which we did. We sent a draft motion to compel over to the prosecutor, and rather than having to urge it formally to get an order for the production, the prosecutor undertook his own independent steps to locate that firearm.
All right,
That
so I'm just trying to get the record to be clear, because I like for the record to be clear.
I'm doing my
Nothing was urged with the court. No motions were given to the court about any other evidence, correct?
Well, in September, Your Honor, I believe we did urge a reset or a continuance based upon this information. But I'm just giving the backstory to the time when we formally discussed resetting the case because of it was not the first time that we had brought it to the court's attention that we were concerned it might cause delays in the process. And I'm further just trying to explain that this wasn't evidence that the prosecutor just had in hand and it was in his file and he just hadn't given it to us. It was information that Mr. Garahan similarly did not have anything more than we did about it at the time that we corresponded. Now, law enforcement involved in the case may have, but it hadn't made its way over to the DA's office with the rest of the discovery.
So that's September, October, November, December,
I'm not quite-
January?
I'm not quite done with the recitation, Your Honor. I do want the record to be clear.
Sure.
So we advised Mr. Garahan of this throughout August and September. Efforts were made to locate this. The prosecutor advised that they had identified the firearm that we were discussing, and they sent it over for ballistics testing. That ballistics testing came at the end of September in accordance with when the court reset this matter for this issue. We engaged an expert witness, Ed Huskey, to conduct his own independent analysis of the firearm. Mr. Huskey advised he would not need a laboratory of his own to conduct that analysis, that he could work off of the bench notes from the firearms investigator for the state of Texas. My records indicate that we engaged Mr. Huskey formally on the 10th of October, but we would have been in discussions with him the week prior. We have sent Mr. Huskey, we believe, everything that he needs to complete his analysis, but Mr. Huskey has advised that he has not finished his analysis. This was the major pressing concern of the remaining settings of the fall, is that we did not have the ballistics analysis. And we believe that this is an extremely material piece of evidence because it goes to the heart of the state's case, which is that Mr. McIntyre was the shooter in this engagement, and that there are at least, there are 4 other individuals in the car besides the deceased. So, and the deceased, just to give a brief summary of the facts, the police that have investigated this have averred that the deceased was ejected from the vehicle or forced out of the vehicle, that he jumped back onto the hood of the vehicle, and that they allege Mr. McIntyre discharged a firearm and killed him. So if, in fact, that firearm that was in the possession of Jalen Bell were to be identified as the firearm, or if it could not be ruled out as the firearm, that would be a material aspect of Mr. McIntyre's defense and an essential one. So that explains the general landscape. Yes, along the way, there were discussions about scheduling conflicts, some of them of a personal nature with some of the litigants, but the primary thrust and reason why we have been resetting this matter time and again since September has been out of concern for the fact that the defense has been unable to independently.
No, this has been reset since May of 2023.
Yes, Your Honor. And I'm just explaining, we did not discover this information until the time frame that I am letting the court know about. We discovered it at the end of July. Throughout the course of August, we were conferring with the prosecution. In September, we had discussions at the bench about this matter on the record, in which it was established that we needed this information, that it was material. The court granted the continuance on that basis. The state was able to produce for us a ballistics report for this firearm. That ballistics report required us to have to go and independently vet whether the report was accurate or if there were any reasons that we might be able to cross-examine the author of the report based upon his analysis. And that's what we have been working very diligently to try and accomplish, but we don't have that report yet. In the interim period, at this court's last setting in December, the court asked if discovery had otherwise been fully complied with, and we believe it had, apart from this continuing issue that we've experienced regarding Mr. McIntyre's jail correspondence, which we've now discovered the reason why we've been unable to download that material is because an associate in Mr. Goldstein's office, who's only made one filing in the entire case, has mistakenly been placed on the clerk's list as the lead counsel. And as a result of that, neither I nor Mr. Goldstein were able to access from our credentials that e-discovery. However, Mr. Garahan has been extremely helpful with us because the state didn't realize why we weren't getting the discovery either until just a couple of weeks ago. And we have been going over and meticulously getting this information on external hard drives and hand it over to us so that we can process it. It's voluminous, but it is largely not relevant to the litigation. At that setting, the court asked of the state of Texas whether or not it had fully complied with Article 3914, and both parties represented that we believe that it had. Since that time period and since the first of this year, and we've
Just 1 second, let me go back to this expert. According to our last hearing on October 10th, 2024, the information I received from both parties was this. I said neither side would be charged with a continuance. State was unable to have some witnesses appear because of the county budget. You requested a testing of the weapon. So everybody knew about this weapon. And I said that both parties have been diligent on doing this. And then the defense was to file a motion to allow for testing of the weapon, which I'm assuming you did and the court signed.
We didn't need to, Your Honor, because
Well,
our
well, just-
expert advised he didn't need it.
And then it says defense expert has no lab, will seek outside lab or state lab for testing. So you all had this information, unless there's a different gun, everybody had this information from October 10th.
That's what I'm explaining, is that by October 10th, I mean, so we discovered there was a problem in end of July, beginning of August. Throughout August, we were looking for a gun. By the September settings, we were aware that there was a gun.
Yes.
And then the state produced a report. On the 10th was the date that we had engaged formally Mr. Huskey, having conferred with him informally for a week prior. We weren't even sure if we would be designating him as an expert at that time. We, at the time that we had that bench conference, assumed, not being firearms experts ourselves, that it would require Mr. Huskey to have access to the physical weapon and to the laboratory analysis. Mr. Huskey has advised us, and I believe that this is consistent with what I've later learned talking to other people in the field, that it is very common in the industry of firearms and tool mark examination for the examiner to be able to run a preliminary round of review and critique of the methodology and the reliability of the data based solely on the bench notes and the work product of the original firearms investigator, and that we would not need access to a laboratory. That led me to have an overinflated sense of how quickly we might be able to get it done if it was simply a matter of paper review. But it has turned out that that doesn't seem to be the case, and Mr. Huskey has not, as of today's date, given me a final report that I would be able to make use of. In fact, I'm having to essentially designate him somewhat prematurely because I don't have an opinion upon which I can confidently say that I would choose
Have
to
you
call.
called him to ask him
Multiple
when he's
times.
available?
Multiple
Well,
times.
what's the answer?
Well, he's physically available for the trial, but he doesn't have any
When will he
analysis.
have analysis done?
He hasn't given me a straight answer.
Well, you need to call him and ask, because this case is not going to be sitting out here forever. And this is the court's problem. My problem is everybody comes in here and wants a special setting for trial. I give you a special setting for trial, and then at the last minute, the week before trial, people are not ready. People want 200 jurors brought down, and then all of a sudden, we need a continuance. So we're going to stop this hearing. We're going to go in recess on this hearing. You're going to call him and you're going to find out when he's going to have it done.
Yes, Your Honor. But before we stop the hearing,
No, we're going to stop it now because you need to call him and find out when it's going to be done. Because I need to know if he's going to have it done in 2 years or 3 years. We'll pick this up where you left off, but that's the number one question for the court. When is it going to be done?
I will report back.
All right, thank you.
Your Honor, may I be heard on about one matter?
Yes.
Thank you, Your Honor. Additionally, this past week, we were advised that the state's chief witness has actually testified under oath, and that's what I was trying to address. The Court of Criminal Appeals, in a recent decision from last June, held that the transcript of such a testimony is discoverable as soon as is practicable. We've been asking for this kind of stuff for years.
All right,
And
so this is what I need though, Attorney Goldstein. I
Yes.
need to know when your expert is saying he's going to be done with this.
I understand, but we also need the transcript of that testimony because the Court of Criminal Appeals has been very clear. We can't be compelled to try the case if a chief witness has given prior sworn testimony
All right,
about the
so
same matter.
I
That's all.
understand what your attorney is saying, Attorney Goldstein, but what I'm telling everyone, I want to know when your expert says he is going to be done with his analysis. So that's what I need to know right now.
Thank you, Your Honor. We'll get on that and be right back with you on the record in just a moment.
All right, thank you.
Thank you for your patience, Your Honor.
Oh, no problem.
I'm sorry, that was 199 days on one list. Yeah. 199.
One this,
Charles, on list. Guys, switch that. Thank you.
Simeon Nevelis.
That's my case, Judge. That's the motion.
Hello. All right, this is set for a motion to suppress. State, are you ready with witnesses?
No, Your Honor. The witness that we need, Officer Lucio, formerly worked for Hollywood Park
Hill Country Village.
Hill Country Village PD, but no longer does so. He now works for Windcrest PD. I did not learn this information until Friday afternoon and was not able to request Officer Lucio to be present. State requests a reset. If the court denies it, we'll dismiss the missing witness.
All right, then what I'll do is this case is coming back this afternoon at 1:30. And it's going to proceed at 1:30. So you have till 1:30 to obtain your witness.
Understood?
Thank you, Judge. My client be excused till 1:30?
Yes. Millard Cummings. Christy Brown. Thank you. You need to be on the first row. Gabriel Diaz. Angel Placencia. You need to be on the first row. Michael Medellin.
Present with counsel, Judge.
All right, first row, please. Jessica Garcia. Adam Herrera, Andrew Garza, Clinton Camacho. Are you Andrew Garza? All right, just have a seat there. You're welcome. Clinton Camacho. This is coming back at 1:30. Jordan Davis.
Morning, Judge, for present.
Good morning. All right, this is scheduled for a jury trial.
Yes, Your Honor.
State, are you ready for this case on Tuesday? We can do jury selection today.
I believe so, Your Honor.
All right.
Judge, we're ready. The only thing is tomorrow at 2:30, I have a plea in federal court.
Okay,
It shouldn't take too long. I
Okay.
just wanted to let the court know about that matter.
sure. No problem.
Okay.
All right, so we can do jury selection this afternoon.
Yes, Your Honor.
All right, so if you'll come back at 1:30, we'll have jury selection on your case.
Yes, ma'am.
All right, Ms. Ferguson, Jordan Davis, 1:30 for jury selection.
Thank you, Judge.
All right, thank you. 1:30. Yes. Orlando. I'm sorry, not Orlando. Excuse me. Alfonso.
Sorry, Judge.
I don't know why I called you Orlando and Orlando Alfonso. So on this case, have you all considered a bench trial?
A bench trial, Judge? I'll talk to my client about it, Your
All
Honor.
right, and if you'll talk to the state about it.
Yes, Your Honor.
All right, thank you.
Thank you.
We're working a deal out on Mr. Wadman's, and I'm gonna go to the pre-file court, bring that to court while he's doing the paperwork. I'll be back. My paperwork, this is what I'm so keep it here at this level, bring that to court. I'll be right back. I'll load it up the court. We're working on the paperwork. Okay, Mr. Wadman's.
Can I see the file on Luis Acura, please? All right, Luis Acura. Hi, how are you doing this morning?
Are you, Your Honor?
Oh, I'm doing okay. I can't complain. It's a Monday. But if we had a vacation today, then Tuesday would be a Monday and a Tuesday, so it's good. Thank you for dressing appropriately for court. Your attorney has asked the court if this case could be recalled for tomorrow.
Yeah.
Because they have a personal matter. So we'll bring you back tomorrow. Are you able to make it tomorrow?
Yeah.
All right, so once you sign the reset form, you'll be excused, okay?
Okay.
And we'll see you tomorrow at 9 a.m. Thank you.
Good, thank you.
The sixth. I don't have any pictures of the application of the night. I got citric. Yeah. 105, 1109. And it just kind of died on Friday. Yeah. It's like the one that we gave it back, but it was very, it didn't shout out the problem. She's 10, she's gonna put 11. Yes.
Richard Garcia, hi. Great. Where have you been traveling? Yeah.
So I'm going to Mexico on Thursday.
Oh, wow.
It's an art week down there.
Colors,
Colors.
the suit color. I love
Oh,
that
thank
color.
Appreciate it. I tried.
You do very well.
All right.
So when are you leaving?
Thursday. I'll be back Monday.
So do you have any other trips planned? Well, I live through you. I live vicariously.
I was thinking of going to Japan for the cherry blossoms, but then, I'm like, I just moved into this apartment across the street and it's like party central. So every day is a party.
Well,
And so I don't want to, I have FOMO, so I don't want to miss out.
well, I had to stay one night. Well, I think it was actually 2 nights at the Hotel Contessa. And
Here downtown?
yes, and I was telling everybody, it was on a Friday, and you know what they immediately said? Mariachis. I'm like, yes.
In the downstairs bar, yeah.
Yes. And
Yeah.
all of the hotel rooms are facing interiorly to the restaurant, and the mariachis went on till 11:30 at night. I mean, it's a great hotel, but I needed my rest.
It's allowed. So I was there about 3 months ago to
Mm-hmm.
it was packed. And so, and I like mariachis, but not that much.
Not when you're trying to sleep.
Yeah.
But the cherry blossoms in Japan, I watched this lady called Sunday Love. Her name is Sunday Love, Sundai.
Sunday love, okay.
Yes. So anyway, she lives in Japan now. And she posts different advice, and she said there's always something to do in Japan.
Yeah,
look
yeah.
if you can find it. But she gives you different locations that are outside the big cities that you can go to. So she said the cherry blossoms, you got to see them. And one time she was showing her followers the cherry blossoms. She's like, man, we got a heavy rain.
So all the cherry blossoms were gone.
Yes.
Kind of like in Mexico City, they have the jacarandas.
Mhm.
Beautiful, beautiful.
Mhm.
But
Oh, I love
after the
those.
rain, it's like dark.
All right.
And then the whole road, all the roads are purple or
All right, am I able to fight with the land here and put one of those up in my yard?
with the HOA?
No, I'll put it in the backyard or whatever. I just think they're
Oh,
so
you mean,
beautiful.
weather-wise?
Yes,
Um,
I'm gonna do,
I know that crepe myrtles do well.
they do, but I've been looking for honeysuckle. I can never find any honeysuckle. And I just want it because it smells so nice.
I think Sonora has honeysuckle, if I'm not mistaken.
Ask her if I can clip a
But
little bit.
but isn't honeysuckle like a vine?
It is, but
Yeah.
it takes me back to my childhood.
Yeah, because it's like a nighttime thing.
Mhm.
Yeah, those are nice.
I did grow a wisteria and it ends up tearing down the fence. And I didn't know that I
Well-
needed so much.
Wisteria is like a weed.
Well,
It grows
sort
like a
of.
weed.
It's sort of, but not really. So, but we shall see. But if you go to Japan,
Sunday love.
yeah, SUNDAI, and the last name is Love. She used to be on America's Next Top Model,
Oh, okay.
but now she lives in Japan. Oh, and actually you should see she has a house in Japan that's sort of like an Airbnb. It's called Blue Bamboo.
Blue bamboo. And is it like a traditional?
Yes.
Uh-huh. So I went to Japan. The last time I went to Japan, I was like, I'm gonna stay in this traditional house, and I booked it, and I get there and there's no furniture. It's all
Yeah.
like, and so
And
then
the
I'm like,
tatami
where,
mats.
yeah, so where am I gonna sleep? There's the tatami mat and there's the rollout thing. I have never had such bad back pain.
Well, she does provide furniture, and she said she desperately wanted the wooden tub. But you know, with the wooden tub, sometimes you get mold and you have to do all this extra, so.
No, this one wasn't that fancy. Blue what?
Blue Bamboo.
Blue bamboo.
Mhm. You'll have to let me know.
That's
when
like
you're-
Blue
when you're
Bayou.
going.
Well, I don't know if I'm gonna go. I'm just going to places that are cheap.
Okay.
So like I went to Madrid for New Year's only because a friend of mine said, hey, there's really cheap flights to Madrid.
Oh,
And what do you mean by cheap? They're like $400.
oh,
Can't
well,
beat that.
you gotta go.
Yeah. So I went
Mhm.
and then all my friends got COVID over there.
Oh, COVID is going around.
And so they canceled all the New Year's Eve party. So I was by myself on New Year's Eve. But there's a million people on the streets, but it wasn't the same.
Hey, it's like Kramer on that
Yeah.
episode. He's like, you can still be alone even though you're on the freeway and you're
They're
stuck in-
surrounded, right?
Yeah.
So the interesting thing is that I spent my birthday in Madrid
Mhm.
a couple of years ago. And I called him and he gave me the name of the restaurant and I said, can you come? Yes, you and your girlfriend. And so Teresa was there, Sandy Herman and her husband and the last daughter. And then they called and they said, oh no, we got the flu. So it was like either I give them bad juju or they don't want to see.
But of course, there are several places that my old stomping grounds. Like, of course, I just love going to Paris, but there are a couple of things that I need to go back to Italy for and go back to Greece for. Italy, I need to take my mom to Italy because I know she'll enjoy the food, and then I have to take her to the Vatican.
You need to buy a house in Italy for €1.
Oh my gosh. Do you know when you buy it for $1, you only have a limited amount of time to fix it up, and if you don't,
You lose it, right?
Yeah.
But you gotta deposit, it's like 40,000 or something. It's not that much.
I tell you what, then I'll deposit, buy it for the $1, and you'll need to come over and make sure that everything is going as steady with the
I thought about doing it, but they're looking for families with kids. They want to rejuvenate.
Yeah,
They're not interested in single guys that
have no children.
and that are just gonna go for the weekend, you know? They wanna, they want. And then I thought about buying in Madrid, but I'd have to buy outside Madrid because everything's outrageous.
And one of the attorneys here, what is her name? It's gonna come to me. She and her husband just bought an apartment in Spain.
Deborah Sanheimer?
No.
Oh,
She has
Deborah's
curly
from
hair,
Spain.
but she and her husband bought an apartment in Spain, so we'll see how it goes.
Oh, because most people are going to Portugal.
Yes,
It's okay.
maybe we should go to Portugal,
And it's super built up. It's like Ibiza,
oh,
it's like hotel after hotel after hotel,
see,
millions and cars everywhere.
stop, I want to go to a place where you can walk everywhere and you see the great
Quaint
architecture.
and-
Yes,
And then if you're gonna do that, if I'm gonna go to a big city, I'm gonna go to Paris or Madrid.
Mhm.
But people that are buying on the beaches are like Uber, Port Aransas with millions of. I didn't like it.
No. Are you gonna run with the Bulls again? You're done?
I would like to go back, but there's so many other things I haven't done.
Yeah.
So-
Laura and I are thinking, we keep thinking, hey, you, me, Richard, all of us, we need to go on a tour. So we're gonna pick a place and
Okay.
do it.
So
I
I
still
I
haven't been
keep
to
have, I
Umbria.
have my bucket list.
Mhm.
So like, I'm missing some places here in the United States,
Mhm.
like Falling Waters
Mhm.
and Mount Rushmore.
See, I have not even been to Hawaii.
Oh, so I went 10 times one year to Hawaii. I'm like over Hawaii.
All right. You're gonna have to help me with that then.
Yeah. Oh, so I'm missing the monastery island in Greece.
All right, did you ever go to that place where they have the pigs on the beach?
Pigs on the beach.
Yeah, the wild pigs. And
Never.
you just go swim with the pigs or something.
Oh, that's funny. I haven't been to Corsica.
Oh,
It's on my list.
okay.
The cherry blossoms on my list.
All right.
But then yesterday I was looking at Facebook and scrolling,
Mhm.
and there's a tour to Iraq.
You know what I want to do? There is some sort of train ride that you can do. There's a Christmas market train ride in Europe, and then there's some sort of train ride here in the United States, Colorado or somewhere.
Durango maybe.
Yeah.
But like for a day.
Yeah, so I want to do that and
Yeah.
see what I see.
The Around the World in 80 Days, the original with David Nevins,
Mhm.
they used that train. They filmed the movie on that train.
Okay, Richard, that's what we should do because we're adventurous. We
I've
should do
done
it
it.
around the world in 80 days.
Yeah. Can you imagine?
That would be interesting. Nicholas
It's
Cameron,
79 days.
Nicholas Cameron,
I just need to approach real quick on that.
yes.
Judge.
Oh, just have a seat. Yes.
I've already told the DA what's going on. Judge, I think I need to get invested.
Okay, sure.
They've offered him a JSAT.
Okay. All right, Mr. Cameron, you can come down. Oh, and Counselor, you're on this side.
Sorry, Judge.
Hello, how are you doing?
I'm all right.
All right. So the question about competency. Explain, because if it's something that an offer has been made and anyone would take it, as I would tell my clients sometimes I would tell them, I know I didn't do it. I wasn't even there, but I'd take the offer. But if it's something where he just doesn't want to take it, if that's the issue of competency, then
Well, Judge, I'm not sure if Mr. Cameron's understanding points I'm trying to make to him, and that's why I'm concerned about it, Judge.
right. You want to go step by step with him or,
I've done that, Judge.
all right.
I'm just trying to get my case dismissed.
All right, so let me just do this. I don't interfere with plea negotiations, so let me do this. State, are you going to dismiss his case? All right, so the state is not going to dismiss your case. And here's the thing, your attorney cannot force the state to dismiss your case. Now, what can end up happening, maybe you all have a motion to suppress, and I decide that there is something that should be suppressed, and maybe that motion to suppress will result in a dismissal of your case. But the state is not dismissing your case. State, have you reviewed his case?
Yes, Your Honor, and an offer has been tendered.
All right, so they've reviewed your case. And based on their review of your case, they say they're not dismissing your case, period. So that's off the table. They say they're not going to dismiss it. So they said they made an offer to you. I don't want to know what the offer is, but have you received that offer? Yes or no? Do you understand the offer?
Yes.
All right, so now that you know they're not going to dismiss this case, maybe you can discuss things openly with your attorney and counsel. If after discussing things with him, you still feel the need for a competency, the court will of course entertain it.
Okay, Judge.
All right, thank you. Are you all ready on McIntyre?
Yes, Your Honor.
All right, we're back on the record in 2019 CR 12495 State versus Tamar McIntyre. Could I have parties re-announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
John Hunter and Jerry Goldstein for Mr. McIntyre.
Good morning, Your Honor.
Good morning.
Your Honor, per the court's request, I have called Mr. Huskey to ask him when he might have a report for us, and he advised that he should have a report ready for us in 30 days.
All right, the good old 30 days. All right, and let me do this because the record really was unclear as far as the court's rendition of the timeline, because the document that I was looking at was not the murder case. It was on the docket sheet, was from the
controlled substance case?
yes, the controlled substance. So let me read into the record the times that this case has been in this court. And actually, this case started in 2019. So December 19th, 2019, there was a pretrial hearing. That hearing, we came back on March 3rd, we came back on April 27th, 2020. Then we came back on March 3rd, 2021.
Your Honor, I'm so sorry to interrupt, but I want to make sure that the court has the timeline accurate because there's a couple of problems. The first being that this case was originally filed as a juvenile matter.
Mhm.
Because Mr. McIntyre was certified an adult in Fort Worth, that became a foregone.
Yeah, I understand that. So I'm reading what's on this document, just reading it into the record. So December 19th, 2019, there was a pretrial and it came back on March 3rd, 2021. Then it was recalled for April 21st, 2021. Then it came back on June 17th, 2021. Then it came back on August 10th, 2021. Then it came back on January 13th, 2022. Then it came back on October 26, 2022. Then it came back on December 6, 2022. Then it to this court, and when it came to this court, it came on May 8th, 2023. And then it was retained attorney, and it came back on June 5th, 2023. Then there's discovery on August 3rd, 2023. Then there's a discovery hearing on October 6th, 2023. Then there was a discovery hearing on December 7th, 2023. Then it was recalled for January 30th, 2024. Then it came back on February 22nd, 2024. Then it came back on March 11th, 2024. Then it came back on April 2nd, 2024. It was set for jury trial in the central jury room on October 11th, 2024. And I bring that setting up because that is a special call for jurors. And the jurors are paid, I believe, approximately $75 per juror. And both, well, I won't say both, but there was a request for 200 jurors to be brought up on that day. And testimony was to begin on October 14th. That did not happen. So we came back on August 27th. Then it was recalled for September 19th, 2024. And then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then it was recalled for November 14th, 2024. Then it was recalled for November 18th, 2024. Then I'm sorry, just one moment. Strike that last one. It wasn't November 14th. Then it was recalled for November 21st, 2024. And then it was recalled for December 2nd, 2024. And then it was recalled for November 21st, 2024. And that's when all parties chose jury selection, again, in the central jury room for 200 jurors. at $75 per juror, which the taxpayers are paying. And we were supposed to be having jury selection on Friday, February 7th. So with regards to your person, you're saying 30 days?
Mr. Huskey advises that he can give us an opinion by 30 days from today's date, Your Honor. Yes. That's the first major point of concern in our motion for continuance. The next point of concern is actually something that I did not learn of until yesterday evening. When the co-defendant was pled way back, like in 2017 or 18, it was my understanding that there was a sealed plea agreement that was entered into for that. The state has disclosed the contents of that agreement, and that's not the issue. What I learned of last night is that it appears that when the plea was received by Your Honor's predecessor on this bench, the prosecution put the co-defendant on the witness stand and elicited substantive evidentiary testimony from the witness about Mr. McIntyre's involvement in this shooting as a condition of the plea agreement, or as, I guess, sort of a memorialization of the testimony that she had promised to give pursuant to the plea agreement. We have not received any such transcript, and I never thought to examine that because, as the court's well aware, a substantive testimonial rendition of the factual basis of the plea is very seldom entered into in state court in Texas. And so it was of no value to us to pull a colloquy of, is this a voluntary plea agreement, or those kinds of things. But it appears that there is substantive testimony of the witness that has not been produced. I advised Mr. Garahan of that issue this morning, and he is similarly unaware of such a transcript, but it is something that we would absolutely need, and we have a right to under 3914.
And by the way, Your Honor, the motion under 3914 and the letters that are a matter of record requested any such statements back some 3 or 4 years ago, anyway.
So that's another major point of concern. In addition to that point of concern, since the new year, since January, and since it was last represented to the court that the discovery process had completed itself, the state has turned over a large quantity of additional material, which I've outlined by bullet point in our sworn motion for continuance, some of which is unimportant, but some of which is substantively significant, including statements from indicted and convicted co-defendants, none of which I've had an opportunity to review because I've been defending another murder case up until last Friday. Additionally to that, when I first informally approached Your Honor back on the 24th of January to advise the court of this concern, I was advised by the prosecution that there has been a reworking of an old phone dump that previously didn't have a whole lot of substantive value to the case that needed to be turned over and was turned over. We've received a flash drive or an external hard drive with the contents of that phone. This is a phone that was recovered from the Kia, which is the vehicle where this incident is alleged to have taken place.
All right, so this is what appears to the court. It appears to the court that this is one of those cases because obviously people are not reading things, that this needs to be brought back every day for you all to decide if you all have discovery. And I will tell you this, I'll grant your motion for continuance. Jury selection will not take place in the jury room. There will not be 200 jurors called up. You're going to be in this courtroom, and it's going to be, I think, Deputy Laura, how many jurors fit in this courtroom? It will be 75 jurors. That's what's going to happen. There will be no other special settings. Do not ask for a special setting. Do not come to the court saying the room is too tight, because this is what you're dealing with, because this will be the second continuance where 75 jurors were called up. And 200 jurors were called up and they're paid $75 a juror. That's the taxpayers that pay that. And then people, I believe you came and said, well, can't we just use those jurors for other courts? No, because nobody calls up jurors on Friday. Those jurors are called up and they're paid. And they're paid for Friday. So do not come back to this court asking for the central jury room. That will not be done. the end on that subject matter. With regards to this witness who testified, this co-defendant, state, do you know who the co-defendant is?
My understanding is, I did speak with, Mr. Hunter off the record, Your Honor. And I was just brought to my attention that allegedly that this individual, and I do know the individual that is named, that he gave me the name. Apparently got on the stand through what Mr. Hunter mentioned to me and was questioned by the judge at the time, I believe Joey Contreras, and also the prosecutor, Jason Goss. I know that she had defense counsel with her. I don't know if there was questioning through that individual. So I just became aware of that literally probably about 10 minutes ago. We'll do our due diligence to look into that. But again, I just became aware of that through defense counsel just about 10 minutes ago.
All right, well, you all need to find the court reporter, whoever that court reporter was, and you all can get the transcripts from them. I'm only giving you 30 days. It shouldn't take that long to get the transcript. If it was a sentencing, then usually those are 2 pages of testimony. Anything else?
I believe it was actually at the plea, and we have no idea how long it went. I've never seen this in a state court before, but it is fairly critical. And what my hope is that the state already has this, but this is precisely the type of issue that arose in the Heath case that I mentioned from back in June.
All right,
And
so
what I'd like to
counsel,
do is make sure that we at least
counsel,
know.
I'm already giving you your motion for continuance.
No, I know. And I don't
Yeah.
want to beat a dead horse. And by the
I
way,
mean, that horse is glue.
well, I understand, Your Honor. And by the way, if it's important to you and Richard, I was in Pamplona for San Fermin back in 1965, and it is an exciting time. But in those days, they didn't have the actual bulls that went into the ring. They had older ones that people, even like little Jewish boys like me, could outrun. That's not true anymore. I would say that my hope is, and what we'll need to do is, the state obviously has access to this information, and they've been very cooperative. I just want to make sure that we do get that transcript and we get it
Here's the
as
thing. I'm giving you all this specific time, and this is the only specific time you're receiving. So today, you all need to find out who that court reporter is and ask them for that record. And since it is I know that some attorneys may go on and on. They get paid by the word with Charles Dickens. So I don't know what happened during that sentencing.
it was a plea, Your Honor. Yes.
Yeah. All right. So that shouldn't take that long unless the attorneys who were on it decided to get paid by the word.
No, Your Honor, the only thing that we've laid out that I anticipate could take long is the production of this phone dump, because.
No, I'm only giving you all 30 days. That's all you're receiving.
Yes, Your Honor. And so to that end, know that we're going to work diligently to process everything that's been produced in that phone dump. But a cell phone dump is typically, terabytes of data.
I'm only giving you all 30 days because let me just tell you, I don't know if you all remember, but this case has been on the docket since 2019. And if you want to say that's juvenile, fine. But it has been in this court since 2023. A phone dump does not take 2 years for people to go through unless they're doing other things, which I understand. Defense attorneys, I
No,
understand.
Your Honor,
how
you
you
don't
have other
understand. We
things to
got
do.
it. We got it on the 24th of January, 2025. That's what I'm saying.
We
The
just
state-
got it, Your Honor.
And so the problem
Well, I
we
have
face
no-
is,
This is what I don't know. I want to know why you're just receiving it then. That's my question. But
That's-
everybody agreed that everybody had everything.
Judge,
That's the point.
just to address the phone dump, it is a phone dump that was given previously. It is just that the certain things that were on our end on Veripic, I don't know how e-discovery, but obviously I don't know if they have access to e-discovery. Was like certain JPEGs or something weren't being able to be opened because of however it got transferred. So that it is the original dump of that phone. It's just that certain pictures and stuff weren't able to be opened.
Now we can use
And
it,
that-
understand it, and hear it and see it. And we weren't able to do that in the form that it was previously given, Your Honor. And may I ask a personal issue on
Jerry,
the, on the
Yeah.
date, on the date of a month. Can we start on Monday, the 10th? Your Honor, I'm in federal court the week before that.
All right, Norma, will you set this the first week in April? This is going to trial.
April,
Yes.
Your Honor, I just want to clarify that something for the purposes of the record on this discussion about the phone dump. The defense's position as to the previous version of the phone dump was that because it didn't have a whole lot of recoverable information on it, and there were lots of images that were not available for use, the state couldn't make use of it any more than the defense could, and that may be to our advantage. So we have to now go through this material for the first time that was not accessible in the original dump. I'm letting the court know this, understanding the court's ruling, and understanding the court's urgency to get the matter tried, because obviously we are going to have to document our due diligence and our efforts with respect to it, and we will update the court as that progresses. But I also want the court to keep in mind, as Mr. Goldstein mentioned earlier on some of these other matters, that one of the remedies the court could entertain is an exclusion of that evidence as being untimely.
This is what we're going to do. Motion for continuance is granted. Norma, set this, since you're taking a while, set this for jury selection is going to take place on March 31st. No problem. March 31st, jury selection.
I'm sorry, is that a Friday or is that a Monday?
That is a Monday.
And then, can that be assumed that it would then testimony start the next day?
Yes. There will be no further continuances without good cause.
Thank you for your consideration and your patience.
You're welcome. All right, anything else?
Not from the state, Your Honor.
Not from the defense.
Thank you.
May I just inquire, is it my understanding that that Joanna's plea transcript, that we don't know if there is one? I mean, we know that she testified. Is the state aware that a transcript has been made?
The
I
state,
have no idea.
the state, no, Mr. Goldstein, my understanding is I got all my information from Mr. Hunter.
Thank
So
you.
I have no knowledge of whether a transcript has already been prepared. I gather based on the circumstances, it has not, and we're going to have to find the reporter and request the transcript to be generated.
Thank you.
Is there anything else?
nothing from the state.
Nothing
Thank
from the
you.
defense.
Thank you, Your Honor.
You're welcome.
May we be excused?
Mhm.
It's real.
I will see you in March.
All right, thank you. Have a good one.
Thank you, Your Honor.
If you get me that information or somebody, I'll find the reporter.
All right.
So I can help them.
Where did he go? John Hunter,
Yes, Your Honor.
if you'll talk to the court reporter and give her the information.
I'll find the
One moment.
Now you're asking them. I'm trying to remember.
I had to guess there was alcohol and there was things, you know, like you don't need to speak about the parent, but probably like.
That would have stuck out of my mind. Final motion change that.
Yeah, I actually. I did.
For an issue with the bond, I'm not gonna say I'm hearing, right?
All right, Adam Herrera. Good morning. Hello, how are you doing?
Very good, thank you.
Where's your client?
He didn't show up and I've lost contact with him. His phone has been changed and so
All right.
I'm not really sure what.
Deputy Laura, could you make an announcement for Adam Adrian Herrera? Right, do you know if he's on a commercial bond?
I don't know.
All right, do you want to try calling the bondsman if he's on a commercial bond
Sure,
first?
sure.
Ms. Ferguson, can you check to see if he's on a commercial bond and if so, who his bondsman is? I think there was a previous warrant issued for him before. So once they give you that information, if you want to reapproach, just let the court
Okay,
know.
thank you.
Thank you. Who is here on Nicholas Henderson? All right. Court is calling 2022 CR 4823, State of Texas versus Nicholas Henderson. Can I have parties announced for the record for the state?
Megan Galloway for the state.
Defense?
Michael Bellable for Mr. Henderson.
And are you Nicholas Michael Henderson? Did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Nicholas Michael Henderson who was placed on community supervision in 2022 CR 4823 for the offense of theft of property 2,500 to 30,000 on July 5th, 2023 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, we're proceeding on the supplement motion, and that's going to be violation of condition number 4 in Gibson County, Indiana. The defendant, Nicholas Michael Henderson, did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, and November 2024 in violation of condition number 4.
How do you plead to that? True or not true?
It's true.
State,
We waive and abandon the remainders, Your Honor.
any objections?
No objections, ma'am.
All right. Did you understand by pleading true to violation of condition number 4, court could find it true, grant the motion, sentence you up to 2 years in the state jail facility?
Yes, ma'am.
And knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. We are asking that you grant the state's motion, adjudicate the defendant guilty and revoke his community supervision and sentence him, will reform the judgment to reflect a sentence of 1 year in the state jail.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Nicholas Michael Henderson.
All right, Mr. Henderson, why were you not reporting?
I hit a bad spot and just kind of gave up. I mean, there's no other way to put it than that. I really just kind of gave up at one point. I reported to the ICOTS officer here in San Antonio. I did report one time to the Elizabeth Greenwell, which was there in Indiana. And we was on a phone contact base at one point, and I just kind of threw my hands up.
So
There's no other way to put it to you than that,
Okay.
really.
Did you complete anything?
I was paying my fines. I had started doing the cognitive thinking program. I didn't complete it, but I was going through it. I was on step 11 at that point, so I was almost there. Other than that, I was just trying to stay busy with a new career and had a lot of good happen, but that doesn't excuse anything.
All right, probation. Does he owe restitution? All right, and did he start, does it show that he started any programs?
The MRT. He started more with regulation there.
All right, that's it?
Yeah.
All right, did you start the theft course?
I had it set up for online, but I didn't start it yet. No, ma'am.
All right, the court is going to grant the motion. Find a violation of condition number 4 true. The court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, good luck to you, okay? All right, and Mr. Henderson, they're taking into consideration another theft case. There you are, Judge. You're welcome. Who's here on Johnny De La Rosa?
Judge, that's me. We're here on a plea bargain deadline and the state is gonna make me an offer, but I wanted to see if the court would let me come back maybe Thursday or Friday. I need to bring a bunch of videos to show my client in
Okay.
regard to the plea bargain.
All right, let me see here. Mr. De La Rosa,
In the box.
if you come down. All right, so this is being recalled for February 6th. The court will not consider any plea bargain agreements after that date. Do you understand?
Yes.
Without good cause. State they're asking that it come back on February 6th for him to
That's
view
what I was
videos.
Okay, sorry.
All right.
I was conferring earlier, they got sidetracked.
All right, thank you.
Thank you. Thank you, Judge.
You're welcome. Deputy Laura, whenever y'all are ready to take him back. Yes.
I did call the bail bonds company on M. Herrera.
Mhm.
They said he's never checked in and never paid them, so they have no contact.
All right. Can I have a prosecutor, please? For someone who did not appear.
Yes, Judge.
Court is calling 2024 CR 012735, State versus Adam Adrian Herrera. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
William Davidson, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 10:31 a.m. The defendant did not answer docket. Deputy Laura, did you make an announcement for Adam Herrera?
Yes, Your Honor, I did. He is not a home.
All right, defense, have you had any contact with your client?
About 6 months ago.
All right, were you able to reach him today?
No, Your Honor.
State?
States are requesting a bond forfeiture or judge's warrant, Your Honor.
All right, the court will grant a bond forfeiture. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, thank you. Have a good one.
Thank you.
Did you all already put this in the system? Because it's showing on my, that there's an active warrant already. Is that correct? Mm-hmm. All right. All right, thank you. Here you are. Thanks. Oh, and there's that file.
Jessica Garcia?
Millard Cummings? Millard Cummings? Yes. So where's your client?
Your Honor, I've been trying to track him down. I was in touch with him on Friday afternoon. He's not appeared yet this morning, so.
Okay, are you ready to proceed then
Excuse
with calling it?
me, Judge.
Are you ready to proceed with calling the case?
I mean, we were set for a plea today, Judge. We're set for trial tomorrow on the case, but
All right, could I see the file on Millard Cummings, please? And is he on a commercial bond?
I think you, Judge.
You want to call the bondsman and?
Let me see if I can, Judge.
All right.
I've left a couple messages in email with Mr. Cummings, so let me see if I can track him down.
All right, thank
Thank you,
you.
Judge.
Jessica Garcia?
Sen. De la Rosa. If you have family here, do not talk to them. You have to-
Charles Wanless. Thank you. Hello.
Hi.
Court is calling 2024 CR 011467 State versus Charles Loring Wanless. Could I have parties announced for the record? I believe that's for the court reporter. You can just sit it there.
Okay.
All right, could I have the parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Joseph Appel for the defense.
And are you Mr. Wanless?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
I believe I have, Your Honor, and I have reviewed it.
All right, so everyone, no talking behind the court reporter when the court is on the record. Court will find that the state is in compliance with discovery. Is there any applications in this case?
No applications, Your Honor.
All right, Mr. Wanless, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, proceeding in a lesser included criminal mischief greater than $750, but less than $2,500.
I'm sorry, you're whispering.
Proceeding on the lesser included criminal mischief greater than $750, but less than $2,500.
Any objections?
No objections, Your Honor.
All right, so off the record.
Thank
So
you.
since you all are, yes, so if you all are proceeding on that, the lesser included offense, y'all are gonna need to change this to the range of punishment, the misdemeanor range of punishment. So that he can say that he knows it. So if you all will just put, and you can put it underneath the second paragraph.
I wasn't sure the best way to do that, Judge, but I
Oh,
thought
no,
we
no.
may have run into a
You have the
problem.
other,
I mean, this,
you want it on the second page.
well, if you put it on the admonishments,
On here.
yes, just so that he can be aware. And so under that first paragraph, if you'll just put the charge and then put up to 1 year in the Bear County Jail and up to a $4,000 fine. I just want to make sure that you know.
Okay.
I
the
wasn't
range
sure-
of punishment
And I
is.
wasn't sure the proper way to do it on their paperwork either.
Oh,
Judge.
no
I just
problem.
wanted-
You know, sometimes it's best to use not the state jail felony paperwork,
Mhm.
but to use the other paperwork and then on that line, just put
And
the
the right
range of
stuff.
punishment. All right, so we're gonna go back on the record. So the state is proceeding on the lesser included offense of criminal mischief as a class A misdemeanor. Defense, any objections?
No objections, Your Honor.
All right, so Mr. Wanless, the state is proceeding on the lesser included offense. So they're not proceeding on the state jail felony. So your range of punishment is up to 1 year in the Bear County Jail and it's up to a $4,000 fine. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he is, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Wanless, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
All right, according to the plea, punishment is to be assessed at 199 days. Any objection to the court writing in the words Bear County Jail?
No, Your Honor.
All right, punishment is to be assessed at 199 days in the Bear County Jail. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
And we've had an opportunity to review those and have reviewed them. We have no objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
With the court's permission, Your Honor, yes.
All right, anything you wish to say on behalf of your client?
Just that he has accepted responsibility for this, Your Honor. He does have 199 actual days in the Bexar County Jail. We respectfully request you to follow the plea bargain, give him credit for all time served, and any time and money spent concurring to show the judgment satisfied.
All right, the court will find you guilty. The court will sentence you to 199 days in the Bexar County Jail. The court will give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because, do you understand?
Yes.
All right, so we can go off the record. Mr. Wanless, I read the police report, so I know there are some mental health issues. Have you been on the medications at the jail?
Yes, Your Honor.
All right, so when you're released from the jail, and I'll have the court called over to the jail to make sure that you're not released at midnight, because that's usually what happens. I'm gonna see if they can release you during the day. You'll need to make sure that you set up your medications. You understand?
Sure.
So.
I'm gonna go to the Center for Healthcare Services, Your Honor.
Yes. All right, make sure you do that. If for any reason something happens and you can't get in the Center for Healthcare Services, or you're lost and you don't know where to go, you can always come back here and we'll make sure that we find a place for you, okay?
Perfect, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
This is a copy for you, Mr. Wanless. Thank you. Good luck.
Thank you.
All right, thank you. All right, who's here? Arturo Camacho Delgado. Hello. All right. So on this case, last time we were here, my understanding is that there are immigration issues. Correct?
Judge, he does have an immigration attorney, but the state and I have
discussed the potential plea offer. I'm just asking for this court to reset it for next Tuesday so that we can accept that plea offer, Your Honor.
All right. So Ms. Ferguson, then if you'll place this for February 11th. All right, so we'll be back on February 11th. Do you have any questions, sir?
No, that's fine.
All right, thank you.
Thank you very much.
Oh, Donata.
Thank you.
Thank you.
Thank you, Judge.
Thank you.
Have an excuse?
Yes.
Thank you.
You still here?
Oh, do you need me to sign something?
Yes, Judge, please.
Sure. No problem.
I'm sorry. Thank you,
Thank
Judge.
you.
Have your excuse.
Yes, and
Thank
Norma, if
you.
you can make sure you put it in the system that an interpreter was here. All right, Michael Cameron. Yes. Nicholas Cameron. That looks like an M, doesn't it? I could be
I
wrong.
don't have my contacts.
All right, where is he?
Judge, I think they took him in the back because I had to run to another court, but you'd already talked to him.
Yes. Could you have him brought out?
I'm still gonna ask for
Mhm.
him to be tested, Judge.
All right, so here's the thing though. If the sole testing is that he's not following your advice.
I don't think he's following me, Judge. I don't think he's,
Okay.
because he's just got this blatant look in his face, so.
Okay.
And I filed a motion to retest the drugs. The state's okay with it.
Okay,
We can get that going along. Waiting on-
we'll bring him back. Hello. Hi, your attorney is requesting a competency evaluation. So we're gonna send you to magistrate's court and they'll perform the competency there. Ms. Ferguson, I need a 30-day reset for competency.
Yeah, March 6th.
All right, so March 6th. So if your competency is done, then I'll take up the matter. If it is not done, we cannot move forward until it's completed. And I'm not in charge of competency evaluations. That's another court. You understand? All right, do you have any questions? All right, and I'm sorry, Norma, you said March when? All right, we'll see you back on March 6th.
And Judge, while that's pending, the state has agreed to my motion for independent testing.
Okay.
I'd like to get that going while we're waiting on that.
Do you know what the cost is?
I don't yet, Judge. Just, I'm happy
right,
to,
if
I'm
you-
happy to, I don't think it's gonna be that much, Judge. I'm happy to forward it if I can just get reimbursed.
Oh, no, you'll be reimbursed, but I have to put amounts in, and if you have an approximation, I'll put the approximation in.
Okay, Judge.
Yes.
Okay.
All right, thank you.
Judge, may I approach?
Yes.
I have Arturo Martinez
Mhm.
and we're close to a plea deal, but they can't get in touch with their complainant. So I was gonna see if we could recall until Thursday.
Oh, no, they're gonna get in touch with the complainant today. They have till 1:30.
Okay, can I come back at 1:30?
Yes, who is your client?
Arturo Martinez.
Let's see what page he is on.
He has restitution.
All right, Norma, well, is that the hold up the restitution amount?
Well, no,
Okay.
well, I mean, he has full restitution.
Okay,
I think, I mean, in my opinion, he does, but they're trying to get in touch with the complainant.
all right, we'll bring you back at 1:30.
Okay.
All right, thank you.
Thanks.
All right, this is coming back at 1:30. Dylan Skinner. Hello, morning. All right. All right, each time you come back to court, you look a little bit worse. Is everything okay?
Why would I look worse?
I mean, I see more bags underneath your eyes. You just don't look the same. Is there an issue at the jail?
They don't feed you with no.
Okay. We will make sure.
I better get a Johnny sack then.
Hmm?
I better get a Johnny sack then.
Well, if you don't, let me know because they're supposed to feed you.
They
All
just don't
right.
Feed you enough.
Just not enough?
They don't feed you enough at all.
Okay, so what did they feed you this morning?
They feed you oatmeal with applesauce, and a little hockey puck of sausage. Like, trust me, it's not anywhere near the food grade average you need.
All right, and what do they feed you for lunch?
Shit.
Okay, well, I mean, I'm sure they give you the same thing every day.
They feed you BS.
Yeah, so it's the bologna with the cheese. That's what I always tell people, jail, you can't order off a menu, but, all right, so where are we on this case with discovery?
Yes, Your Honor. So we have provided defense with a flash drive that holds 17 videos. I believe he was requesting 12, but there were 20 videos total. I just presented him with the CD that had one additional video. The issue we were having is that the files were corrupted, and so that's what's slowing everything down. I've sent a request for SAPD to send us those 2 corrupted videos that we are missing again, so that we can provide those to defense, but that's the status of where we are at.
All right, Ms. Ferguson, recall this case for February 18th for discovery. Right,
Thank you.
you're welcome.
Thank you. Judge.
Angel Placencia.
Yes, Judge, we're ready. Morning, Judge.
Good morning, Deputy Laura. But you know what I eat every day? Oatmeal. Like I had oatmeal for dinner last night.
Rolled, like steel cut, rolled oats, the instant.
Oh, I just do Quaker. You know. All right, so on this case, where are we on discovery?
Judge, I believe I received all the discovery. I was able to confer with Ms. Galloway. We received an offer. I spent quite a bit of time in the witness room to talk to my client.
Mhm.
We need a little bit more time to discuss this. If we could come back for a plea deadline date.
All right, how old are you?
18.
All right, yes, you need time to think over everything and think about the consequences, okay? So is the end of February enough time for you, or do you need more time?
End of February sounds good.
You sure?
Yes, ma'am.
Will you be able to talk to whomever you need to talk to by then?
Yes, well, actually, I was thinking about just getting stuck here right now.
I don't want to rush something.
No, I don't either, because he's so new.
Right. If we could come back at least 3 weeks into February. And Your Honor, he does, if I can ask, pretrial 75-mile radius restrictions.
Mhm.
Um,
What is the issue?
he's gonna be working or off the record, he's gonna be accepting a job.
Just 1 second. The employment?
Yeah, I've been working since June.
All right, so if you'll talk to the state, I'm sure they'll have no objections and just provide the court with an order.
Okay, I will talk, and in the meantime, can we have a get with Norma for a reset
Oh,
date?
I'm gonna give you a date now.
Oh, yes.
Ms. Ferguson, I need a 30-day reset date for plea deadline date.
March 6th.
All right, so on March 6th, you need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, ma'am.
All right, once you sign the reset form, you're excused, and thank you for dressing appropriately for court. Michael Anthony Medine. Yeah. Hello.
Good morning, Judge.
All right, so where are we on this case?
Judge, this is our first setting. I've requested some additional discovery. It's too large to download.
Okay.
And there's additional, I believe, some CPS records of the file. I may need to get a protective order in order to get those.
All right, so first, with regards to the CPS records, is that something the state you have in your custody?
Yes, Judge, and I can do the protective order right now.
All right, yes, if you'll do the protective order. And the additional discovery, other than the CPS records, what would be the additional discovery?
There were body cam footage and possibly some co-band video, but their files are too large to download. So I need a physical copy. I've not received yet.
And there are no cell phone docs, are they?
No, Judge.
All right.
So Mr. Castañon has identified the serial numbers of what he needs, so we've conferred for him to provide me a drive so that I can get that to him this week.
All right, Ms. Ferguson, I need a 45-day reset for discovery. All right, we'll be back on March 20th. Does that interfere with your spring break?
It does not, Judge. Thank you for
All right, sure.
remembering that. Thank you.
I remember you have children. All right, thank you so much for dressing appropriately for court. Just have a seat. They'll bring the reset form to you. Once you've signed it, you're excused.
Thank you, Judge.
You're welcome. All right, Millard Cummings. Is the attorney back on Millard Cummings? Cody Salazar?
Good morning, Your Honor.
Good morning. Hello, so, hi. State, did you tender an offer?
We have not, Your Honor. I think we did speak with the complainant and we did provide a disclosure to defense, but I think this is a case where we need to speak to the complainant in person and we just need time to meet with her in person.
All right. So an offer was due December 16th. And then it was recalled for January 30th. And I know we were in trial or something else was happening, so we didn't have court on January 30th. This will be the last time this case is reset, state, for an offer. Yes.
Judge, I was in the hospital on
Yes.
the 30th, so
How are you doing?
better. Blood pressure's,
You got to keep the blood
Yes,
pressure
yes.
down.
they're taking care of me.
All right, we don't want to lose you.
Thank you, Judge.
All right, so let me see here. All right, so we're going to recall this on February 18th. Is February 18th a good date for you?
I believe so, Judge.
We don't want to interfere with any doctor's appointments. I know
Yes.
they're probably doing follow-up.
They're on me, Judge. Goodness. 18th is right after the holiday. It's a good day.
All right, Ms. Ferguson, recall this for February 18th, please. All right, we'll bring you back on February 18th. Do you have any questions?
No, ma'am. Thank you.
All right, thank you. Have a good day. It's for an offer. Elliot Vela? Elliot Vela? Oh, I'll look at that in a moment. Andrew Garza? Okay. Hello, how's it going? All right, so is he entering a plea or is this going to jury trial?
If those are two options, Judge, we're more likely to go to a jury trial. If we can continue negotiations, we might be able to work out a plea at a later time, but I could explain if you want me to be candid.
Sure.
The issue we're having is the charge, we have 2,500 or we are, if I could speak frankly, Andrew, we are 2,500 right at that number. So fair market value of the items listed could be at $40 or $35. We're working on that exact amount and finding evidence to confer with, to establish that fair market value. Whether or not my client, I think my client would like to, is leaning towards that. But I want to establish a fair market value in a fair and reasonable way that we can agree to.
All right.
That's the candid explanation.
No, I appreciate that. I'll see y'all back at 1:30.
Thank you, ma'am.
Thank you. Thank you for dressing appropriately for court.
Sure, thanks.
Court is calling 2018 CR 1071 State versus Christopher Salinas. Could I have parties announced for the record for the state?
Salinas. Megan Galloway from state.
For the defense?
Robert Featherston representing Mr. Salinas.
And are you Mr. Salinas? Mr. Salinas, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Christopher Salinas who's placed on deferred adjudication in 2018 CR 1071 for the offense of possession with intent to deliver a controlled substance, penalty group 2, 4 to 400 grams on July 6, 2018 for a period of 5 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 5 in Bexar County, Texas, the defendant Christopher Salinas did then and there fail to report to the supervision officer as directed for the months of May, June, August, October, and November of 2024 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainder, Your Honor.
Any objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is not, Your Honor, based on the allegation that was pled true to, the state is asking for 5 years to do so.
All right. Defense. I mean, the rank, that's the minimum.
Yes, Your Honor, and we're not in agreement on that.
All right, what are you requesting, counsel?
Your Honor, the court needs to be aware that in April of 2023, Mr. Salinas went into the hospital to have L3 and L5 on his spine repaired. He remained in the hospital for 3.5 months and then was released. Since that time, he's been in constant chronic pain from the spinal repair. His chronic pain, Judge, has led to his continued drug abuse. That led to his failures to report. It's led to his failures to provide samples for urinalysis. He recognizes that he has a drug addiction problem because of his chronic pain, and that has not been alleviated. He's been unable to work. He can't stand for long periods of time. These are contributing factors to his failure to report in 2024 to his probation officer. He's not committed any new crimes that have been alleged in the MTR. Probation is recommending substance abuse treatment facility. We would like the court to consider that recommendation of substance abuse treatment facility. Mr. Salinas would like to go to SADA and successfully complete that in hopes of getting control over his chronic pain and then getting the appropriate prescriptions subsequent to be able to handle his pain. And then we're respectfully requesting that the court consider an 18-month extension as recommended by probation in order to be able to accomplish these goals. And I thank the court.
Thank you. All right, Mr. Salinas, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Christopher Salinas.
All right, so your attorney said that you were in the hospital, and I'm taking that as true, counsel.
Thank you, Your Honor.
So my question is, you were in the hospital April 2023, and you were there for 3 months. So that means May 2023, June 23, July 23, and I'm gonna even give you August 2023.
I was actually, after that, I went to physical therapy for a month.
Okay. No, I'm giving
Oh,
you,
okay.
I'm giving you 4 months after that.
Yes.
So you're in hospital April 2023, and I'm giving you till September. I'm not even gonna consider you're not reporting September 2023 from April 23 to September 2023. So October, did you call probation?
Yes.
No. Here's the thing. Did you pick up the phone and tell them, I'm going through some problems and I cannot report?
No.
All right. Have you done anything on probation?
Yes, I've done some community service. I mean, I did about 12 hours recently. And
All right, so that's 12 hours. You were placed on probation with a previous judge since 2018.
right,
And from 2018 to now, you're telling me you've only done 12 hours of community service restitution?
24 total.
All right, 24 hours since 2018.
Yes.
And you were actually in court with me on January 17th, 2023. A previous motion to revoke had been filed and it was withdrawn for your conditions to be altered and amended. And those conditions from January 17th, 2023 was to do 90 sober meetings in 90 days. You were supposed to be residing with your mother. Did you continue to reside with your mom?
Yes, I still live with my mom.
All right, and then you were supposed to do the UA hotline until further notice. And you're supposed to be doing intensive outpatient treatment. There was supposed to be regular reporting by Zoom or in person, so you didn't even have to go in person. You could have done it by Zoom. And there were to be field visits 2 times per month and partial GPS for work. And then you were allowed to run errands or whatever you need to do on Saturday and Sunday from 8 a.m. to 5 p.m. And you haven't done anything. That's the problem. So I don't think I should continue you because you haven't done anything. And in this court, what do I always say? If you have an issue, pick up the phone, call probation. If you feel they're not addressing it, you can always come to court. And I know that I would have told you, if you have a drug problem, in this court, my thing is, if you have a drug problem and you think you're going to use, pick up the phone, call probation. I'm not looking to revoke people because they have a drug problem they're about to use. I'm looking to try to get you help so you won't use. But you didn't do any of those things. And you've been extended before. And the fact that you've been extended before, that means that there've been problems before. Otherwise, nobody would have extended you. And so you've been on probation since 2018 and you really have done nothing. So I'm not going to continue you.
Yes.
Yes.
Yeah, from 2018, I completed all my programs that I was supposed to complete. And the reason why, I mean,
You told me the only thing you had done was community service hours.
before that, that's when when we came back the first time.
Did you do your 90 sober meetings in 90 days?
I've done meetings. I have.
Now, did you do your 90?
Completed. No.
All right. I just don't think you're a good candidate for probation. And let me explain to you, one, I'm finding it true based upon your plea of true, but here's the thing. You have to at least try. There's nothing I can do if people don't try. And I can't continue to give chance after chance when people don't try. I mean, the only other thing left for probation to do is to come to your house, give you a ride to their location, or either come to your house and sit down with you and bring somebody to, have the classes come into your home, and they don't have the finances for that.
Your Honor, may I address the court?
Yes.
Judge, everything that you say is quite logical about what should be done on a community supervision program. Here, for Mr. Salinas, there is this extenuating circumstance with respect to his back problems. A very extensive stay in the hospital. It's quite uncommon to hear of a 3.5-month stay in a hospital for anything nowadays. So there was something significant there. And quite frankly, I'm not a medical doctor and I don't really know much about L3 and L5 in your spine.
Oh, no, I appreciate what you're saying, that for them to keep you in the hospital for 3 months, it is extensive.
And the court's explanations with respect to 2024, because this is in 2023, with 2024 is quite valid. But this is a gentleman that found himself, he's He's out now of the hospital. He doesn't have a job. He doesn't have insurance. He's got chronic pain. He needs medication for that. So he goes to controlled substances for medication of that. And now the fear factor for going to probation is through the roof, because he knows if he goes to probation, he knows he's going to have to give a sample. And he's unsure as to whether probation is going to consider his chronic back pain as an adequate explanation. And I understand his fears are valid in that respect. If it wasn't for his back surgery, Judge, I would have no leg to stand on with respect to revocation.
Mhm.
I'm asking the court for its mercy here with respect to Mr. Salinas, and allow him to complete an inpatient drug treatment program, and then allow him to go ahead and complete his community supervision program. I thank the court for its time.
All right, thank you. And I want you to know, I heard your counsel's argument, and I think it's a very good argument. But the issue is 2023. Here we are in 2025.
Yeah.
Yes.
Thing is, I had a surgery in my lower lumbar, disc 5 and disc 3. I didn't get it repaired. They had to shave it off. So it's very fragile.
No, I understand it's fragile, but here's the thing. You didn't even pick up the phone to call probation.
My probation has the copies of all my medical records. They
No,
know
did you pick up the phone and call probation? Because let me explain something to you. The allegations in the motion are that you didn't report for May, June, August, October, and November of 2024. What that means is you didn't go to their office, you didn't call them, you didn't do any of that.
June, July, August, September.
I mean, you played true to June, August, October, and November 2024, and May of 2024. You played true to that of not reporting.
I've seen my probation all the way up to September. October is when I stopped. Since from there to there, I have reported.
All right, so this is.
That's a misunderstanding. So since October and on is when I stopped reporting. Before that, I've talked to probation officers. I've been to the office.
Here's the thing. I don't know
just-
why you stopped reporting in October. All you had to do was pick up the phone. Right? And you know, because you've been before me before, you know that if there's an issue with probation, let the court know. You know, if there's an issue where you think you're going to use, or you have a drug problem and you're feeling weak with drug use. That's why I did the 90 sober meetings. And that's why I said, if there's an issue, let probation know, and then we will address it. Your counsel can tell you normally, unless there's something else going on, if somebody has a drug problem and they're actually trying to maintain their sobriety, I normally don't revoke for that. Right? So the court is finding violation of condition number 5 true. The court will find you guilty. The court is going to grant the motion, sentence you to 5 years in prison. That's the minimum. And I'm doing the minimum because, one, the state requested it, and also considering your health issues. Give you credit for any time served. I'll recommend the therapeutic community and counsel. I'll retain jurisdiction. I'm not sure if he qualifies for that because I don't have his history before me, but if he does, I'll retain jurisdiction.
Thank you, Your Honor. And if the court would entertain a suggestion because of his back issues with the court, consider a full house arrest at his house.
No, I will not do that, but I appreciate your asking.
Thank you, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Are you sentencing to 5 years TVC?
Yes.
Yes. I have never even been in trouble.
All right.
Since from 2018, this is the only reason why I'm keep coming back from failure. I've never gotten a new case or anything. Your Honor, please.
All right,
I'm
so
done.
did you review the trial court certification of defendant's rights to appeal with your attorney?
Yes.
All right, because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing, I understand what you're saying. There are many people that come before me. Guess what? They've never been in trouble before. This is their first case and it's a felony. But by that same token, do you know how many people who have never had a case, they're not on probation? I mean, I can only help you with your probation if you show up. Otherwise, I can't help you. All right, the court is calling Tommy Lopez. And counsel, you can explain that to him about the retention of the jurisdiction.
I will, Judge.
Okay. Who's here for Tommy Lopez?
I'll be here, Your Honor.
Thank you. How's it going?
Good, how are you?
All right. Court is calling 2024 CR 011089, State versus Tommy Lopez Jr. Could I have parties announced for the record for the state?
Ashley Jones?
Defense?
Adam Flores, Your Honor.
And are there any applications in this case?
No, Your Honor.
All right, Mr. Lopez, I'm sorry, counsel, have you received all discovery?
Yes, Your Honor, I have.
Did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are waiving the habitual enhancement allegation.
Any objection?
No objection, Your Honor.
All right, Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The state will take in consideration 2024 PF 10226. There's to be no contact with the complainant, and you are to agree to a civil protective order at the Justice Center. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor. On the protective order, it'd be for the time he's serving in prison, 2 years, I believe.
I'm not in charge of when he is to serve his time as it relates to the protective order. I'm just here to tell you, a part of your plea bargain agreement is he's to agree to the civil protective order. So has he already agreed to that?
Yes, Your Honor.
I'm sorry, Judge. My understanding, yes, is that he has agreed to it. Our complainant is going to be applying. And so there is a process that it goes along with that.
No. All right. So when you serve that, that is not under this court's jurisdiction. Do you understand? Did you, that's yes or no? Yes or no?
Yes, ma'am.
All right. Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Yes, yes, Your Honor, but we waive them, Your Honor.
All right. Then to the offense, how do you plead?
Guilty.
State any evidence?
Yes, state offers states exhibit 1 and all attachments.
No objection, Your Honor.
All right, state you may be excused. Did you review the waivers and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He takes responsibility, Your Honor, for his actions, Your Honor.
All right, what is, because this complainant came to, I guess, a homeless location to give his mother food. What is the mother's name?
Nora Vital.
I'm sorry, what?
Nora Vital.
You say Vital?
Mhm.
Vital?
Yeah,
And the first name Nora?
Nora.
All right, so why did this escalate to this point if he's just there to drop off food?
He just started on me. He
No.
wanted to fight with me.
No, what it says is the victim's son stated that the victim was there to drop off food to his mother, who is homeless. Victim stated he got into an argument with mom's boyfriend and his mother, which then escalated to the suspect repeatedly swinging a machete at him while chasing him. Victim stated that he picked up a skateboard nearby and used it to protect himself from being struck. So according to this, he's just there to give food to his mom who's
We
homeless.
were in the park. We had a barbecue. We were in the park. We were gonna do a barbecue.
So you're saying you're not homeless?
At the time, we weren't homeless.
All right, so you're saying all of this is not true, and the collection of one glass pipe that's in the police report, you're saying that's not true?
Well, Your Honor, he's pleading guilty because is the best thing for his case, Your Honor. The complaint gave a contradictory statement to the DA, but he's willing to plead guilty to get the case over with, Your Honor.
All right, court is going to find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money run concurrent. Take in consideration 2024 PF 10226. There's an affirmative finding of deadly weapon. There's to be no contact with John DeLeon. You agree to a civil protective order in the Family Justice Center. The court will note for the record that the defendant has previously agreed to that, and there's to be no contact with Nora Vital. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Did you sign the trial court certification?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Maybe excuse, Your Honor?
Yes.
Thank you, Your Honor.
All right, state, do you have the PF dismissal?
Yes, Your Honor, we grab that.
Defense, you need this dismissal? Do you need the cost number?
Yes, Your Honor.
It's 2024 PF 10226. Who's here on Michael Gerard Gonzalez?
I'm present. He is still in custody in the back. Your Honor.
All right, we'll see you back at 1:30. Oh, he's bringing him up. Okay. Who's here on Christina Martinez?
That's all from Ms. Martinez. This is a motion for a competency evaluation.
All right. Then, Ms. Ferguson? On this, I need to reset up for a competency evaluation. And where is Christina Martinez? Okay. Yes. All right. So attorneys, you all are not ready if your client is not in the box. All right, Christina Martinez. Hello. Hi, what date? All right, your attorney is requesting that you see a doctor. So we're going to bring you back on March 6th.
So I have to stay.
Well, have you had a chance to speak with him today?
No, I didn't get the chance to talk to him.
We talked some time ago, and it was, may I ask the court's procedure? Will the court go ahead and order testing at this point, or we do that on March?
Oh, no, you will go to the magistrate's court to have the testing done, and
I
you'll go
didn't
to
know
have
that.
this order heard.
Thank you, Your Honor.
All right.
I'll talk to her now.
Okay. All right. All right, Michael Gonzalez. Oh, counsel, do you need to continue speaking with him?
Well, Your Honor, I just texted Christine Oliver. She had blocked it.
Okay, thank you. Juan Pettis. Who's here on Juan Pettis? Who's here on Ezekiel Martinez?
I am, Your Honor.
Hi. I just noticed you guys. I have tunnel vision. Where are the babies? Oh, they're there? Oh, wow. Okay, I'm gonna have to step down to see them. Yes.
So I just got appointed to him today and he wants a trial, a jury trial.
All right. And I'm assuming you're not ready for trial today.
I'm not ready.
All right. Mr. Ezekiel Martinez? All right, if you can step down. All right, Mr. Martinez, it's the court's understanding you're requesting a jury trial?
Yeah.
Oh, I see he's tired. You know, they say when you yawn, if other people yawn with you, that means that they care greatly for you. Just throwing that out
Like
there.
a ripple effect.
Yeah, and you know, I found it to be true. So, Mr. Martinez, state, were you able to tender an offer to him? All right, so you're rejecting the state's offer?
Who was that? Yeah.
Here's the thing. I need you to be 100% focused, okay?
Yes, sir.
Because this is a serious thing. You're charged with evading arrest detention with a previous conviction. The state has tendered you an offer. Do you understand what that offer is?
Yeah.
That's yes or no?
Yes.
All right. So do you need time to think about that offer or do you want a jury trial?
I'm not sure I get to think about it.
I can call you back on Thursday.
Okay. Yeah, I think about it.
Are you available?
Thursday would be good because then I can review the videos and.
All right. So Norma, if you recall this for Thursday, February 6th.
Well, yeah, February 6th, I'll be here. Yeah.
All right.
I leave in the afternoons.
All right. So that will be your plea deadline date.
Okay.
All right. Thank you.
Okay. So I'll see you here on Thursday.
Thank you.
Okay. I can come to over the phone. Do you have phone access?
Yeah.
Yeah, you can call me. Or I'll zoom in with you. I'll order you to zoom in. Okay?
All right, Michael Gonzalez. Hello, hi. All right, so where are we on this case?
He was just recently indicted, Your Honor. We still need to go over discovery.
All right, and I'm assuming there is maybe a plethora of discovery.
Correct.
Yeah, I think so.
Yes.
All right, Ms. Ferguson, if I can have a 45-day reset on Gonzalez.
Thank you, Jeff.
You're welcome. And it's discovery.
Thank you, Judge.
All right, March 20th.
Thank you, ma'am.
Judge.
Excused.
Yes.
Have a seat, sir.
Juan Perez. Gabriel Diaz.
Hi, Judge. Good morning.
Hello, where's Gabriel Diaz?
Well, that's the question now, isn't it, Judge? So Norma suggested that I approach you to figure out how you want to handle it. I have my receptionist reaching out to him to find out, is he planning on joining us today?
All
So
right.
to find out if you want to recall us at 1:30 or you
Yes, we
just
can
want to
come back
call
at
the bond
1:30.
forfeiture, whichever you.
No, what do you prefer?
I have other settings to get to.
All right. All right, Court Deputy Laura, can you make an announcement for Gabriel Diaz? Court is calling 2024 CR 010128, 2024 CR 010131, 2024 CR 010149, State versus Gabriel Diaz. Can I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense?
Carl Alexander for Mr. Diaz.
All right, this hearing was scheduled at 9 a.m. It is now 11:37 a.m. The defendant has not answered docket call. Deputy Laura, did you make an announcement in the hallway?
Yes, Your Honor. Did he is now.
All right, defense, do you have any contact with your client?
Judge, and I was checking my phone when you were calling the case. I apologize for that because I was texting my receptionist. So she did, as per our procedure, reach out to him last week, notify him, remind him of the court date. She tried again this morning after I arrived and realized he wasn't here. And as of during today, we did not have any contact.
All right, state, your request in each case?
Forfeit the bond, issue a warrant.
All right, in each cause number, the court will grant the state's motion for a bond forfeiture. In each cause number, your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
May be excused.
Yes. Oh, you okay?
Yeah.
You need to take a break?
I didn't take my medicines.
Oh, go ahead. Jesse Arriaga. Good morning.
We're actually set for trial tomorrow.
Yes.
Ashley had wanted to approach this morning, although I thought. I think she just wanted us to advise the court that we were going to accept the new offer they just made.
Okay.
Because she wanted to be able to not have to call witnesses and get ready. I think she just wanted to put me on the spot
All right, sure.
to do that. And of course, she's not here to see that I did that.
All right, so,
But he did agreement jump for a plea issue.
all right, so that'll be done tomorrow then.
Yes.
All right, thank you. Robert Castillo? Yes.
Ron, I've got two motions that I wanted to present to the court. We've got a trial date. I think it's trial date, either that or a last, March 4th.
Yes.
And so I had the first motion I've got is our third motion for access to the vehicle and for a motion to appoint our expert Gregory Pratt. He is former FBI. He was on the ERT for Sutherland Springs as well as Fort Hood.
Oh, well, you can have whatever expert you want to have, so.
So what we're looking for is actual bullet slugs and bullets. The second motion that we have is I received a notice through e-discovery that the state had filed a search warrant to remove the bumper from that Tesla. And I've got several requests regarding that. First, if that has not been signed, that the court would deny that warrant.
All right, so here's the thing. One, I don't know if it's been signed or not. Number two, it sounds as though that this needs to be set for a hearing.
Okay.
So if y'all will come back to the tomorrow, the court will hear it, and if y'all will confirm motions, because this is off docket.
It is
Yeah,
off
Judge,
docket,
and
Judge.
had counsel, I conferred with me, I mean, the search warrant has already been executed and it goes to what he's alleging, so I don't really anticipate that it would be an issue, but I will speak with him.
I'm happy to confer, Judge.
All right,
Absolutely.
and then your client will need to be here. Is your client in custody or on bond?
He's on bond, Judge. Could we set that for Thursday? Is that a possibility?
You have to speak to the coordinator because it depends on our trial setting.
Understand, Judge.
All right,
Thank you.
you're welcome. Yes. Cummings. Hello.
Good morning, Your Honor.
Yes.
Your Honor, my client's bondsman earlier today, he had been reporting regularly. They weren't aware of any issues. I've not heard back from them. I've tried again to call my client and send him another email.
Well, actually, I don't know why he's on the docket today because I show him as being set for tomorrow.
We had recalled it, Judge. We had conferred last week and we had accepted a plea and we had rescheduled it and set the court date for today. So
All right, 1:30.
today?
Mhm.
Okay, Judge.
All right, thank
Thank you.
you. That's 1:30. All right, Michael Anthony Medellin. Why do I have this case? The attorney is Orlando Castellon. It's already been heard. Is there something else?
McGee and Oviedo.
Oh, no problem.
McGee, we're gonna come back at 1:30 and do a plea.
All right, so McGee, you say McGee, 1:30?
Yeah, they gotta get some files for the stairs.
All right, that's a plea. All right, thank you.
And I got Oviedo too. It's all right.
All right. Christy Brown? No. Oh, okay. I don't know why I have this. All right. Oviedo? Yes. I'm sorry. Oh, just give me 1 second. Okay, no problem. Oviedo? If you'll come down, where are we on this case?
We would like to reset it in 2 weeks. I just actually got notice of today's hearing last Friday.
Okay.
But I think we probably have a plea worked out, but I've got to check out something, so we just need 2 weeks if we could.
All right, Ms. Ferguson, if you can recall this in 2 weeks, please. I think that puts us at February 18th. All right, February 18th. Thank you.
I'll be back this afternoon.
All right, thank you.
Thank you, Your Honor.
You're welcome. All right, Christine Brown. Hello, hi. Well, I saw your case is being set for a motion to suppress today. Ms. Ferguson, is there a reason why her attorney is not here?
McGee. Martinez Ezekiel. Martinez. Christina. Tommy Lopez. Michael Gonzalez.
We're trying to, have you had contact with your attorney?
No, ma'am.
But we're here on Brown for a motion to suppress.
Your Honor, may I address the court?
Yes.
I requested the officer who received what is believed to have been the consent search from Ms. Brown. That officer is not coming in for today's hearing, so if the court will allow me, I'll file a motion to dismiss for missing witness.
All right, thank you so much.
If you'll
So-
excuse me.
Yes. So do you want to wait for your attorney or do you want the dismissal?
Dismissal, please.
Yes,
Thank you.
you're welcome. So how are you doing today?
I'm doing fine, thank you.
I better today,
Yes,
right?
ma'am.
Thank you for dressing appropriate for court. All right, so if you, he's doing the dismissal now. If you'll just have a seat and I'll get that to you.
Thank you.
You're welcome.
Cody Kraus.
All right, have you conferred with the state?
Yeah, First Judge.
Yes.
Good morning, you know. Yes, I have, and we've come to terms. But I'm supposed to be in New Braunfels, and the judge over there is not nearly as
Oh, no, don't do that.
well.
I mean, until I get a chance to touch the dogs that are back there, I don't know if you want to, yeah.
Well, no, I was gonna say something nice.
I know, you were gonna butter me up and say,
Well,
Judge over there is not nearly as nice as you are.
Well, about both of you in one fell swoop. Well, actually, Judge, you busted me on that. I gotta be honest with you.
You get the dismissal from him so I can let.
But
And if you could give that to Miss Brown. Thank you. Miss Brown, the state will tender your dismissal. Is that a district? I mean, is that a district court?
it's a county court, and I told him I was in felony court, so I
Yeah,
understand.
now.
Yes, Judge.
And if you need to, we'll call them.
That'd be nice.
All right, Miss Ferguson, which county is it? If you give Miss Ferguson the number and we'll see y'all back here at 1:30.
Thank you, Judge.
All right, Norma, Kraus is coming back at 1:30 for disposition. And what page is Kraus on? All right, thank you. All right, we're still waiting on that, so. Laura. You have some paperwork.
I know I can. Let me see our babies. Is it okay if I see them? Hi, guys. Oh, hi. Can you guys bring the babies up? I'm sorry, I didn't even know. Yes, you can. Maybe that'll bring people down, but they're great. So they usually come to help children who are testifying. And adults. And adults. And yours. And yours. You want blue? Yes. See, she knows, right? She did. Come give you some love.
Hi, great. Saturday looks so good.
Oh,
Let's sit
thank
right
you.
here. I know, the next one I'll have to, they're right here and then I'll have to come to her. I'll go sit. There you go.
Oh, baby girls. And boys.
Andrew.
Come on in, Rashawn, come on in.
Get in there, get in there. Here, give me your phone.
Come on in, stay.
There you go.
Sit.
Right in there. Coco.
Coco. Turn around.
Sit on this side.
Sit.
It's okay.
Oh, Coco's like, no, not today.
Gotta sit sideways. In front. No, Piper, look. Piper.
Piper's doing her own thing. Okay, and can I tell you, they're so strong.
Wait.
I don't know.
Bless you. Okay, wait, Piper. Piper, look.
But thank you guys so much for all you do to help children out.
And adults.
And adults, we need
And
this
the
today.
juror, yes.
And the jurors.
Thing, so yeah, we'll be swinging by every now and then. Call me, let me know, and I'll be here. And, yeah, we'll make sure that.
Oh, I appreciate that. Thank you so much.
For
Bye,
going to
baby girl.
I can put her at your feet and you can just rub on them.
Oh, see, that's, okay, we need that,
There
right?
you go, you'll be rubbing your feet, right? Sit. Oh, that's it. Okay. I know, right?
So guys, I don't think we're gonna get anything else done. But they, the level was here, they take it.
Oh, yeah.
That's why we bring them.
Oh, they're so awesome.
Even you, so if you're stressed out, just let us know, we'll come here and love on you and be there for you and.
Oh, awesome, thank you so much.
That's being paid, we're being paid with it, actually.
Yes.
So this is easier.
Oh, awesome. Well, in this part, we're all dog lovers and pet lovers.
Oh, yes. So, yeah, so they're behaving.
They're so awesome.
Right, I will see you.
All right, thank you so much.
Let me know the next event, I will be there.
Okay, awesome.
Saturday was just so crazy for me, so.
And they'll let you know if you have child witnesses or anything.
Yeah, tell us when it comes to the jury, because our last one over here. So we see the jury, so whenever they go back to the jury room, we're gonna talk about the last.
I will let them know if there's issues where the jurors want some.
Relaxing, exactly. He's one of the good ones. He's a good one. He's a
You're on a.
Yes, thank you guys so much. And they feel so great, right? 0173. Okay, everybody just take a rest now.
So yeah, keep that down. Thank you. Oh, yeah.
Take care of it. Do you want me, if you give me the number, I'll call over there directly.
The judge is Judge Gray.
I'll call. I'll take care of it.
Thank you, Judge.
You're welcome. All right, who's here on one? Pettis? All right, Mr. Pettis, if you'll come down. All right, Deputy Lord, now everybody is relaxed. We've decompressed.
I don't know what you're talking about.
All right, so today is plea deadline date.
Yes, Your Honor. We're going to trial for sure. My only problem is they drilled 4 holes in my teeth and made me wear a denture so the rest of my mouth doesn't swell. As the court can tell, my speech is not all that well right.
All right.
So just, we would like that. He wants it quickly, but I probably need a couple of weeks to at least speak right.
All right. Have you talked to the state and considered a bench trial, or do you want a jury trial?
I would like a jury trial, and we did negotiate on 2 occasions for possible plea bargains. We haven't been able to do that.
Do you want a bench trial or a jury trial?
I don't know what's the difference now.
All right, a jury trial is where 12 people will be sitting in the box. Witnesses will be questioned. And the jury will make a decision if they can come to a decision on whether you're guilty or not guilty. A bench trial is where I listen to evidence that is presented and I make a decision on whether you're guilty or not guilty. What I can tell you is I've had bench trials in this court before. Some people I found not guilty, some people I found guilty. What I can inform you of is if the state proves their case beyond a reasonable doubt, you're going to be found guilty. If the state is unable to prove their case beyond a reasonable doubt, you will be found not guilty by the court. I just listen to the evidence and I make a decision based upon the evidence that I hear. You understand?
Yes, ma'am.
So, do you understand the difference between a bench trial and a jury trial?
Yes, ma'am.
All right, do you want a jury trial or a bench trial?
A jury trial.
All right, Ms. Ferguson, recall this in 2 weeks for jury trial, please. It should be a short trial. Am I correct, State?
3 days.
Yes, it's 3 days.
All right,
All right, February 10th is your jury trial date.
February 10th. Thank you, Your Honor.
You're welcome.
Thank you,
Thank you
ma'am.
for helping me with
You're
my
welcome.
case.
They'll bring you back over dressed for trial in whatever clothing you have at the jail. If you wish to be attired in something different, you have to do a clothing exchange with your attorney. Do you understand?
Yes, ma'am.
All right, thank you.
Thanks.
All right, everyone. If there's no one else ready right now, we are going to take our recess for lunch.
Good.
Yes,
For Mr. Pettis, what did you say that trial date will be?
February 10th.
Understood, thank you.
All right.
February 10th,
Yes.
because I thought I also heard you say 2 weeks.
Oh, I did, but that's the date Norma gave, and the defense is okay with that date or in agreement with that date.